Hi, this is Dr. A, and this is the fourth and last lesson on Chapter 11 on healthcare law for the 5th edition of the Basics of the U.S. Healthcare System in our Intro to U.S. Healthcare class. And we're going to look at some non-discrimination practices in the workforce, the EEOC. We're going to look at some pandemic legislation and reproductive rights. Okay, so steps for non-discrimination practices in the workplace. So first is to establish compensation criteria. So what are the criteria to make, the pay somebody for a certain job, and then how do you factor experience in, etc. So that it's very clear and guidelines that are set forth that can be followed. You also want to do pay audits and document these audits for several years to make sure that people are paid accordingly according to your compensation criteria that you've outlined. It's also good to do pay audits that are, well, it's not really pay audits, but it's good to do kind of market research where you see what other employers in the area are paying for the same job to make sure that you're competitive, right? You want to document all your retention processes that are related to pay. So all the things, the perks and all the things that you do to retain employees, to help them grow and all of that. You want to train your managers on providing objective performance evaluations. So they're not, based on being buddy-buddy, but we have criteria and things that we have to meet. We have to assess for certain things. Then you also want to develop and implement a rigorous statistical analysis of pay distribution. And this is across, all the different metrics that could be discriminated against, and to make sure that your pay distributions are correct. So because of all of this and discrimination, we also have the Equal Employment Opportunity Commission, or the EEOC. So an individual who thinks they are being discriminated against can file a complaint with the EEOC, which then notifies the employer. So once the employer is notified, they are responsible for safeguarding any written information regarding the complaint, meaning they cannot blast it. They cannot say, hey, Joe such and such just filed an EEOC complaint against a company and all of that. Like, this is, put the lid on it. We got to keep it, the complaint, and keep it under wraps. And then the EEOC then can investigate the complaint to determine if the employer did violate any laws. If a violation is found, then the EEOC will use first conciliation or negotiation to attempt to resolve the issue without going to court. So again, they negotiate between the employer and the employee that was wronged. If that conciliation is not successful, then litigation or going to court or going to trial is the next step. The EEOC is also responsible for developing regulations for any of the EEOC laws and its amendments. So it has written regulations for the ADA, for the ADEA, and for the Equal Pay Act. And so it's good for you to be familiar with that if you're in the position of hiring or firing people. It also issues guidelines on other issues such as sexual harassment and affirmative action. The EEOC acquires information from employers regarding their practices to make sure that they are compliant also. Employers with 100 or more employees must file an EEO-1 report that reflects the number of women and minorities who hold positions. This report is then used to assess any potential discrimination trends. The EEOC also provides employers with written and electronic media education on discrimination, and it sends this information to the HR department, Human Resources, right, which then is responsible for disseminating information with training classes that everybody has to attend that are mandatory. Sometimes it can be online, it doesn't have to be in person, but they're trainings, modules and things that have to be completed by the employees. Okay, so now let's move to pandemic legislation. So there are several legislation that were passed during the pandemic. The Families First Coronavirus Response Act. This law responded to the growing health and economic crises with provisions for paid sick leave, free testing, and expanded unemployment benefits. The Coronavirus Aid, Relief, and Economic Security Act, or the CARES Act. This was a $2.2 trillion economic package that focused on the healthcare industry, so sustaining all the hospitals, the employers, and boosting telehealth services, which were much needed during the pandemic. The 2020 Paycheck Protection Program and Healthcare Enhancement Act provided funding for hospitals, funding for COVID-19 testing, and funding for small businesses. Again, trying to keep businesses open, hospitals afloat, everybody operating, testing getting done. Because, of course, testing is not free. I mean, it was free at the point of use for us, but, you know, somebody is still developing all of these tests and had to be paid for. Trump then ordered the Operation Warp Speed project, which enabled the Food and Drug Administration to give emergency approval for the use of Pfizer, Moderna, and Johnson & Johnson vaccine. And these happen in months rather than in years, so get them to market quickly. And then the last one was the 2021 American Rescue Plan. The funds were targeted to homelessness, to state and local governments, give enhanced tax credits, unemployment benefits, COVID-19 testing, contact tracing, and school support, all again related to the pandemic. Some executive orders that were signed, so that are also related to the pandemic. President Biden signed 10 executive orders mandating masks on public transportation, increasing testing for COVID-19, and increasing travel restrictions to and from the United States during the pandemic. He ordered the use of the Defense Production Act, which mandated companies to manufacture supplies such as PPE and the tests that were needed, and a lot of hospital supplies that were needed. And it increased funding to state and local governments to increase the vaccine programs. So disseminating the vaccines out to the public, right? Okay, so the last issue we're going to look at are the reproductive rights. So in 1973, a landmark decision made by the Supreme Court ruled that the U.S. Constitution protects women's rights to choose to have an abortion without excessive government restriction. This has been this way since 1973, and then recently we've had a lot of changes. So this initial decision struck down many federal and state abortion laws. The case was brought by Norma McCorvey, known as Jane Roe, who became pregnant with her third child. She wanted an abortion, which was illegal in Texas unless the mother was in danger of losing her life. Her attorneys filed a federal lawsuit against a local attorney, which is Henry Wade, indicating that the state abortion laws were unconstitutional. The court found in her favor, which was appealed to the Supreme Court. And then in June 2022, the Supreme Court overruled Roe in the Dobbs v. Jackson Women's Health Organization, indicating that abortion was not considered a right. The Dobbs v. Jackson case challenged the Mississippi 2018 Gestational Age Act, which banned abortions after 15 weeks with exceptions for medical emergencies. Then the Women's Health Organization filed suit indicating that the 2018 Act violated the previous 24-week established point of viability. So for reference, generally speaking, if a fetus can reach 24 weeks gestation, then it has a chance to live outside of the womb, so that if there's a delivery, it's possible for the baby to be born. They're little bitty, they're like 1 pound little bitty babies. So that's kind of where that 24-week came, because that's the point where they're viable outside of the womb. The Supreme Court upheld the 2018 Act, which overruled the Roe versus Wade. So existing anti-abortion state laws, which were not valid because of the federal Roe v. Wade decision, are now triggered to be legal because of the reversal of this decision. So most states are passing anti-abortion laws because of this decision. In some states, there are abortion laws with no exceptions due to rape or incest, requiring the victim to carry a child to the full term regardless of circumstance. So this could impact a mother's mental health stability. Also, the maternal mortality rates in the United States, particularly in women of color, are very high. So this rate could increase with the mandate of carrying more babies to term. Also, we must say also, like, regardless if a mom chooses to have an abortion, it can affect her mental health. And if she is made to carry the baby to term that she doesn't want, it can affect her mental health. So Either way, situations where there's an unwanted pregnancy is going to affect a mom's mental health for sure. So in conclusion, to be an effective healthcare manager, it is important to understand basic legal principles that influence the work environment, including the legal relationship between the organization and the consumer, which is the healthcare provider and the patient. As both the healthcare manager and healthcare consumer, it is imperative that you are familiar with the different federal and state laws that impact the healthcare organization, where you live and where you practice, and for your profession, right? It is also important that you understand the differences between civil and criminal law and the penalties that may be imposed for breaking those laws. You especially need to be very careful with HIPAA and do not lose your job over, looking up something that you had no business looking up, right? New laws have been passed and older laws have been amended to reflect needed changes regarding health care and to continue to protect its participants from both a patient and an employee-employer perspective. The recent overturn of Roe v. Wade will continue to have impact across the country, and this is, I'm sure, not anywhere near done. So this wraps up the last of our healthcare law chapter, and our next chapter is going to be on healthcare ethics.